Okay, some new documents dropped today in the state versus Brian Koberger, and I thought it was interesting because one of them was the state's supplemental response to the defendant's fifth motion to compel. And basically, Anne's been posturing and whining that she hasn't received anything, but Ashley Jennings basically bitch slapping her. She listed almost 2.5 pages of when they have responded to motions for discovery and what dates. So, if Anne's going to play that game, the prosecution's going to play that game too. And so I will post that here for you to look over that document. Now, these next two documents aren't nearly as exciting. They are just a motion to seal an exhibit based on the fifth motion to compel, and the judge granting the motion to seal. So you can look at these two. Now, yesterday, a Second Amendment motion about the IGG came out, and I'm seeing a lot of people misinterpreting it. They're saying that this means that the defense gets all of the IGG, but that's not what it's saying. It's saying that the IGG that was already turned over, which is, we don't know how much, but we know it's not all of it, because the judge went and looked at it and chose only what he thinks needs to be turned over. But it's saying that not only does the defense expert witnesses get to look at it, but now their independent investigators also do. And these investigators are unnamed. But it's saying that anybody else that needs to look at it, it still needs to go through the judge. Now, it also mentions the mitigation experts family tree, and people are getting confused about that. The mitigation expert family tree has nothing to do with the IGG. In a death penalty case, they hire a mitigation expert to look and see if there was any history of mental illness or other conditions that could have caused Koberger to commit these crimes, and therefore he shouldn't be getting the death penalty. He should just get life in prison. So they will use this information in the penalty phase. So was there any history of child abuse, mental illnesses, schizophrenia, etc.? The mitigation expert cannot look at the family tree for the IGG and vice versa. So they will not be comparing. So any YouTuber that you hear saying that they will be comparing these family trees, that's not what's going on. Completely separate things. IGG, separate from the mitigation family tree. So I just wanted to get that out there because I'm seeing a lot of YouTubers that are confusing their viewers. Okay, now let's go back and talk about why the IGG did not have to be turned over in full. And technically, it didn't have to be turned over. ICR 16 lays out what has to be turned over in discovery. And the IGG was not used to obtain the arrest warrant. It was not shown to the grand jury, and it's not going to be introduced as evidence by the prosecution at trial. And therefore, under the discovery rules, it did not fit the definition of what needed to be turned over to the defense. It legally was not discoverable. However, Ann Taylor argued and made a point to have hearings about it, to where Judge felt like, I guess he should do a happy medium, and he decided to allow her to see some of that discovery. But technically, it did not need to be turned over, and here's the ICR. So this is just so you can see where it is on the website. It's under Idaho Criminal Rule of 16, Discovery and Inspection, Mandatory Disclosure of Evidence and Material by the Prosecution. And the section you want to look at is 4, Documents and Tangible Objects, because the IGG family tree and information was documents. On written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy or photograph books, papers, documents, photographs, tangible objects, buildings, or places, or copies or portions of them that are in the possession, custody, or control of the prosecuting attorney, and that is very important. because it says are material to the preparation of the defense, are intended for use by the prosecutor as evidence at trial, or were obtained from the defendant or belong to the defendant. So let's talk about those three qualifiers. Were they needed for preparation for trial by the defendant? No. Because it wasn't used for the arrest warrant, it wasn't shown to the grand jury, it's not being introduced as evidence at trial. Therefore, it is not essential for the preparation by the defense. Second, is it being introduced by the prosecutor as evidence? No, it's not. They've already said they're not using it. And third, did it belong to the defendant? No. He left his DNA at a crime scene. That's no longer his. And he has no ownership over anybody on the family tree in the databases that were used for the IGG. So it doesn't belong to him. So it doesn't meet the three criteria. It was not discoverable. But the judge tried to strike a happy medium and allowed Anne to see some of the IGG. But I still cannot figure out what her end game on this is, because she can't claim fruit of a poisonous tree because they didn't use the IGG for the arrest warrant. And even if they did, you can still say that they eventually would have stumbled upon Kohberger anyway, just because of the car as well, the video footage of the car and cell phone evidence. So even if they were introducing the IGG and it got kicked out as not being able to be used at trial, it still isn't that big of a deal. So I don't understand why she's wasting all her time and energy on this. The only thing I can think is that it's more posturing. She's trying to say, well, if the FBI went about getting this from databases illegally, then what else did they do? So I think she's just trying to plant a seed in the mind of potential jurors, because the IGG was not used to obtain the warrant and it's not being issued or shown at trial as evidence. So it's irrelevant. But for some reason she's trying to make it relevant. But it is a defense attorney's job to throw things at the wall to see what will stick. So, but I just feel like she shouldn't be wasting time and energy on that when there's other things she could be challenging. But I guess we'll see what she has lined up when it comes to trial.